started.
Okay, great. Erica or Kim, are one of you going to do the housekeeping?
It is me today.
Oh yeah, Danielle today. Okay, that's right. Sorry.
Welcome, committee members, liaisons, and members of the public to today's Legal Services Trust Fund Commission Rules Committee meeting. Thank you for joining us. We are using Zoom with the goal to foster a more inclusive environment and effective meeting. If you would like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can use the raise hand feature. In efforts of transparency for those joining this public meeting, whether by phone or by Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate discussion. All LSTFC and committee meetings will be recorded and posted to the State Bar website. A friendly reminder that this is a video conference, and please be aware of your surroundings behind you. Thank you.
I mean, would you like me to take a roll call?
Yes, that would be great.
Okay, great. Asaraf?
Present.
Whitemaster?
Here.
Blakemore?
Here.
Connolly? Friedman? Corey? Oh, I see you. Okay, great. Meeker?
Here.
Okay. Judge Seligman? We have quorum, and I'll do roll call for our liaisons and staff as well.
Okay.
Christine Ganon, Tony Copeland, Selena Copeland.
Present.
Bonnie Huff. Danielle McRae.
Here.
Erica Carroll. Brady, are you here? Okay, I see him. Great. And I'll turn it over to you, Amin, for public comments.
Okay, thanks, Dawn. Thanks, Danielle. Hello, everyone. Welcome to the Rules Committee meeting. I would first like to call for any public comment. Do we have anybody on the line that wishes to make a public comment?
I don't see any members of the public. I see Judge Seligman just joined us, so I'll make a note for roll.
All right. Hi, Judge Seligman. I think we've got one agenda item today. It's a deep one. It's a significant one. But I think we were just sort of speaking at the beginning. It doesn't look like we'll probably go the full 3 hours for folks' planning purposes. But why don't we jump right in? I'll turn it over to Erica.
Thank you. Hi, everybody. Let me just pull up the PowerPoint really quickly. So today, we'll be revisiting the topic of defining and demonstrating indigency. For those who were on the committee last year, you know that we first addressed this topic late last year, but have since put a pause on sort of wrapping it up or proceeding with some of the outstanding issues given the statutory change that was pending. So when we first addressed this topic, some of the issues that we identified regarding indigency, the two main ones were that the definition of indigent person under the Business and Professions Code could be further clarified in order to help grant recipients comply with the requirements in terms of income screening and ensuring that services are provided to qualified individuals. The other main area of inquiry is the impact litigation and advocacy law, impact litigation and advocacy work reports. These are reports that are submitted by grantees to demonstrate work that they've performed to benefit a group or a class of persons rather than individuals. So particularly in the case of qualified legal services projects, there's been a question about how to demonstrate a benefit to this group of individuals because the current guidelines require, in many instances, quantifying a percentage or a number of persons served. And there's been a lot of feedback regarding the inability to do that, or the very onerous process of doing that in order to submit these reports annually. So So we'll go through each, first dealing with the definition of indigent person, and then move on to the ILR reports. And I should say, if anybody wasn't on the committee last year, or if I'm kind of going through anything too quickly, feel free to stop me for more detail on some of these preliminary matters. But just wanted to go through the timeline quickly of where we are now. So we first addressed this topic back in October of 2020. There was a discussion and recommendations, and the main recommendation that came out of that meeting was to change the statutory definition for the client income threshold under 6213D to increase that from 125% of the federal poverty level to 200%, or to at a minimum explore that change based on feedback that was received from the legal aid community. At the commission's meeting in November of that year, there was discussion on the topic, and it seemed that more research and analysis was warranted, and so the commission delegated authority to a subcommittee to make the final decision about whether a statutory change would be appropriate to support. And so in December and January, State Bar staff conducted a webinar with current grantees to get their perspective on making a change to the statute, mostly focused on the impact of changing the income threshold, but also another portion of the statute references 125% of the federal poverty level related to the funding formula. And so there was discussion about whether that portion of the statute should be changed as well, or just the client income threshold. And so the webinar was held in December, and then a survey was sent to grantees. And based on the feedback from the survey that was presented to the subcommittee in January, and the ultimate recommendation was to increase the income threshold, but leave the funding formula alone. So change the income threshold to 200% of the federal poverty level, while keeping the funding formula based on the proportion of individuals at or below 125% of the federal poverty level in each county. At the Board of Trustees meeting in January 2021, that change was adopted as part of the State Bar's legislative priorities. And so the legislation was pending for much of this past year, but this past week, Governor Newsom signed that legislation. And so the income threshold will be changed to 200% of the federal poverty level for income eligibility purposes. It also, when that legislation was introduced, the person sponsoring it also added language related to veterans benefits. So there's also new language related to disability compensation, veterans disability related compensation, and that that should be taken into account or discounted, I should say. It's an exception to income under the statute now. So again, these are sort of the main categories under the definition of indigent person. Mainly we've dealt with the first bullet point, although we do still need to discuss the definition of income itself, and then the other qualifying characteristics, the pro bono allocation, and disability related expenses. So just a recap of the governing authorities. These are all the authorities that are relevant to the codification process. The first three are the ones that are implicated in looking at this topic. So the statute, the State Bar rules, and the eligibility guidelines for legal services projects. When we looked at the governing authorities, we learned that there was no corresponding State Bar rule to the definition of indigent person, as well as the statute section 6218, which relates to establishing eligibility guidelines, grantees needing to establish eligibility guidelines, and then Legal Services Trust Fund Program Eligibility Guideline 2.3.4, that relates to the ILR reports. And so the initial proposal was to look into creating a State Bar rule that would help clarify or interpret some of these other authorities. So Business and Professions Code section 6213D, this is just broken out into sort of the four main components of that code section, which now says that a person whose income is 200% or less of the current poverty threshold would be a qualifying individual for services, or somebody who's eligible for supplemental security income, free services under the Older Americans Act, or the Developmentally Disabled Assistance Act. There's also a section related to projects that provide free services of attorneys in private practice. Those organizations are allowed to use a higher income threshold. In most instances, that would be higher than 200%. And then related to all categories under this definition, the income of individuals with disabilities, their income should only be calculated after deducting disability-related expenses and medical expenses. So what we've determined, or what we came across when looking at the statute, is that there is no definition of terms like income and household under the statute. And programs have run into issues in terms of determining, what should be included in an income calculation and what can be excluded, as well as how to count members of a household. When the working group first looked at this, one of the relevant materials that was also consulted was the Legal Services Corporation's definition of income. The Legal Services Corporation provides funding to a number of grantees that also receive IOLTA and EAF funding. And they had more of a fleshed out definition of income that pretty much tracks the definition of income by the IRS, but in more sort of colloquial terms. And so after looking at that, that was the recommendation from the working group, was to adopt that definition, which has, I think, about 12 or 14 different categories to help organizations make that determination about what would be included under that term. That same section says that it is up to the grant recipient to define the household and provide some guidance about, that anyone who's contributing to the income of the members living in the household, but that it leaves some flexibility for that determination. The other thing that the working group considered was questions about income exceptions. So the Legal Services Corporation also has a section on exceptions to income. That was first considered before the recommendation to change the income threshold to 200%. The LSC exception, so LSC has 125% as the income threshold, but the exceptions allow organizations to go up to 200% under certain circumstances. But given that the California statute now automatically goes up to 200%, using LSC's exceptions didn't seem as necessary. There were also questions about confirming things like the approach to how to attribute income to minors, whether it should be looking, at other members of their households, or whether, if it's if the minor has any income at all. Those were kind of questions that came up, but there wasn't a definitive recommendation from the working group. In the materials that were provided, the initial recommendation was to allow organizations to make exceptions to income under extenuating circumstances. I think one of the examples given was in the case of a person who's experienced intimate partner violence, who, maybe still living with their abuser, but to exclude that person's income from the calculation, situations like that. So the proposed rule that was in the materials kind of had a more broad, rather than picking sort of each question that may come up and providing a specific answer, just more broadly allowing organizations to define when they would make exceptions to income and under what circumstances, and that would be subject to commission review, and that the commission could reject the eligibility guidelines and exceptions provided by the grantee if it felt that it was inconsistent with the state bar rules and the statute. The other thing that was looked at was the the higher income threshold for programs with the pro bono allocation. So as I mentioned, there is that higher income threshold that the State Bar has always interpreted as being only applicable to organizations that receive the extra funding through the pro bono allocation every year. There had been feedback from the legal aid community that some organizations felt that was too restrictive, and that organizations that have pro bono work that they perform but are not receiving the allocation should be able to avail themselves of a higher income threshold. That has never been the way the State Bar has interpreted that, but that was feedback that we received from the legal aid community. But the working group's recommendation is to not necessarily change the current practice, to leave that alone.
Brady has his hand raised.
Oh, I'm sorry. Go ahead, Brady.
I just had a question. The feedback that we got, was it from organizations not getting the higher threshold? I had understood that at least one of them was advocating that if they did a little pro bono work, that part of their work should be subject to the higher threshold. Were there also members of the community who were saying that if they did a little bit of pro bono work, their entire program should get the threshold, or were they advocating for sort of a carve out for their pro bono work?
My understanding is that it was the former. So to the extent that, a case may be assigned to a pro bono, that it could use the higher income threshold, but that's my recollection. I may be mistaken, but I think that was sort of the main.
Okay.
But I think, in either instance, the recommendation would be to stick with applying this to only organizations that receive the allocation, given that, that's sort of consistent, I think, with how the word project and the discussion of services of attorneys in private practice is used in other parts of the statute.
Yep.
Erica, Selena has her hand raised.
Okay.
I was just going to add that that's my recollection as well, although I haven't reread all the comments from a year ago. It was that not that the pro bono allocation would apply to the entire organization, but just to a project for which they have, the way they deliver that project is pro bono. If you had like a housing clinic where you use all pro bono attorneys, for example, but not for the whole organization. And I think some of this just kind of goes back to where organizations see the difference between the AMI and the 125%. And it's such a huge difference that organizations that may serve over 125 and between the 75% or 80% AMI, they feel like they have to discount a lot of clients that their brother and sister and sibling organizations don't have to. So I think that's just where that really came from. But I'm hoping that with the increase to 200%, that helps a lot of organizations serve clients who were previously over income that they would have had to turn away and would have only been able to be counted for pro bono allocation organizations.
And then the last bullet point is, clarifying or confirming that the deduction for disability related medical and special expenses before determining income, whether you're talking about the pro bono programs with the higher income threshold or sort of the standard definition for 200% of the federal poverty level. There was also discussion about the definition of indigent person, not based on income, but based on other qualifying characteristics. So the interpretation in our office has always been that, recipients of supplemental security income, or in cases where maybe they're not receiving it yet, but can show eligibility, would be qualified to receive services under IELTS and EAF funding. Under the Older Adults Act, that's been interpreted as 60 or older. And then for the Developmentally Disabled Assistance Act, that would be based on the definition under Title 42 of the US Code. So for any of these individuals, our office has never required organizations to do any sort of means testing, that meeting any of these definitions would be sufficient for an individual to qualify for services.
And Erica,
Right,
Jim
that
has
looks
his
like
hand raised.
Jim has his hand up.
Yeah, I just wanted to bring up two issues, and maybe Brady can comment on one of them. One, thing that we did do last fall is we did empirically demonstrate that if we shifted to the 200% in terms of the funding formula, that there would be a shift of money from the rural counties to the urban counties. And we actually demonstrated that empirically, and that was one of the reasons why saying that we should keep the funding formula the same. But the other issue I think was raised by Herman is that by increasing it from the 125% level to the 200%, although it does make us easier to track the LSC definitions, but it is increasing the number of people who are eligible. I think from the data that we used last fall, it goes from something like 7.29 million to 12.5 million, which is an increase of 5 million almost, or a little bit over 5 million, which is a substantial increase in terms of the number of eligible people covered, but with no increase in funding. So that means it could be stretched a lot more. And then finally, the one issue I had, I briefly discussed this with Carol before, and I'll leave the answer to this to the practicing attorneys because I am not a practicing attorney, but I'm a little concerned about in the same statute, on one level, we're defining income very broadly, that the 200% of the federal poverty level is defined by the census, plus the over 60, plus the disabled. But when it comes to funding in the same statute, we're using income in a very narrow definition of just 125% is defined by the census. And does defining the same term, income, differently in different parts of the statute, does that create a potential problem? Because if I were an urban program, I would say, well, we ought to use income as defined consistently, and therefore we should shift more money to the urban areas. That's my only concern.
So I'll just make one comment on that, or two maybe. I think the difference in the definitions was deliberate, right? I think that was, we had this discussion, I think a while back, that when we were changing to 200%, we didn't want to make that applicable to the funding. We wanted that simply to be an eligibility. But as far as the language goes, I mean, from a construction standpoint, so long as, in my view, so long as it's clear that there are different definitions being used within the statute for each of those terms, for that term in each of those contexts, I think it's probably okay. I'd defer to others who might have more experience or comment or knowledge about that, but I think it's just a matter of how much detail we're putting in and how much clarification we have to include. Judge Seligman?
Yeah, I agree with your analysis. And basically, as long as the statute is clear, you can have the different usages. And here, I think the language is clear and they are for different purposes. So I don't think that creates a legal issue. Obviously, you have the policy question of whether that makes sense, but I don't think it creates a legal issue.
Yeah, I had a look of confusion for a minute because I was hearing you say there were different definitions of income, but that's not, it's just there's a different threshold applied in different parts of the statute. Right. And again, it's the statute says what it says, or will once the amendment goes into effect. So again, it's a policy decision that was made, and I guess it could be revisited in the future. Sorry, Selena, for jumping in.
No, I think you basically were saying half of what I was going to say too. Legislative staff did ask if we wanted to change the other piece as well, because they noticed that it was staying at 125%, and we just explained no, because the impact on rural communities would be a loss in income to those communities, and that was not the intention with this shift. So legislative staff did ask, and we answered their question, and they were happy with it. I did have a panic moment though, where when they asked, I was like, wait, did we mean to change that? I had to go back to my email chains.
And I would echo the other comments that were made that, in the funding formula, the source of the information, it's not even determination that we would have to make about income. We're getting it from the ACS, which is already determined, you know, who is at that level of income. I agree. I don't necessarily foresee it being a problem in terms of implementation. So the working group recommendations for the definition of indigent person in terms of establishing a state bar rule, the recommendations that came out of the process were to adopt the legal services corporation definition of income and to allow exceptions to income under extenuating circumstances, to adopt clarifications to the categories based on other qualifying characteristics, and to confirm the deduction of disability related costs. The attachment that was included with today's materials has been updated because we first reviewed a proposed rule last year in October, but there have been some changes since then. And so the one that was in this iteration also includes language regarding the new exception for veterans disability related compensation as well. And then there was also discussion, this was more of an internal discussion that came up recently, but about the possibility of codifying that approach that we mentioned about the pro bono allocation, given that this office's approach has been consistent, but that there does seem to be possible confusion on the grantee's end about whether they can or should be able to use the higher income threshold. So that's more of a point for discussion. That hasn't actually been through the working group because that was sort of a more recent realization or discussion that came up. So I don't know if you all would like to stop and sort of discuss the 6213D portion first before talking about ILAW reporting, or if you want me to go through the whole thing and then we can talk about everything at the same time. I'm happy to do either. I know it's a lot of information, so if we want to deal with one issue.
Judge Sullivan has his hand up.
Yeah, I just, what is the higher income threshold for pro bono allocation?
It's essentially based on area median income. The actual language, let's see. So organizations, the bottom left on your screen, they can use 75% or less of the maximum levels of income based on this section of the Health and Safety Code, which relates back to area median income.
Okay, well, that probably makes my next question impossible to answer, but on a rough sense, how would that compare to our new 200%?
Yeah, I was looking at that the other day, just trying to do quickly sort of a comparison. And in some counties, it's actually probably going to be about the same as 200% for counties like Imperial County, I believe, or some of the other more rural counties. In counties like Los Angeles and Alameda, I think it's probably still significantly higher than 200%. I want to say that 200% is somewhere around 56,000 for a family of 4. And this calculation in counties like Alameda or Los Angeles, I think would probably be higher in the 60s or even 70s. So for that same family size.
But it's a fair statement, is it not? I think Selena made this point that raising it to 200% reduces the disparity, shall we say, significantly from what it was.
Yes, in many counties, I mean, in all counties, it does reduce the disparity, and in some, it actually eliminates it or brings it almost to being equivalent. And then in the other counties, it reduces the disparity. Yeah.
All right, thanks.
Yeah.
And Jim has his hand raised.
Yeah, I was just going to say, we did some of that analysis, and in the urban counties, especially like Alameda, San Francisco, Orange County, the 200% is way lower than the 75% of the median. But again, like Carol mentioned, Imperial County and some of the poorer rural counties, the 200% comes very close to it. Of course, the other thing that offsets it, since this is pro bono, that if you look at the ratio of attorneys to poor people, the ratio is much, much higher in urban counties than it is in poor counties. So the higher level, given the higher ratio of attorneys, it kind of, in my mind anyway, kind of washes out.
So, sorry, did anybody want to discuss this portion first, or Duan, do you think I should keep going?
I had just one thing to refresh everyone's recollection, is that we had talked about AMI as a possible way to change, but looking at nonprofits with multi-county services, it was actually quite different, because then they'd have different income thresholds for every county they provided services, including statewide organizations. And area median income actually goes quite high in urban counties. If you put it there, for I think San Francisco, it's like 96,000. And so that's quite a big jump. And there was some concern of a whole lot more eligible clients if we tagged it to that. And so having it at 200% seemed to be a reasonable jump up that would increase eligible clients, but would not become like the floodgates that organizations would have to turn away so many more clients based on resources rather than on income eligibility. But we did discuss AMI over several meetings a year ago.
It's also more difficult to get consistent population data at the AMI level from the census.
Catherine, do you have your hand up?
Yeah, so I guess just to the question, so is it like, I found the recommendations quite good and helpful. So is there a reason not to discuss those and vote on those before we move, or is it too connected to what we're deciding next? It just feels like there's solid recommendations that we could approve on the definition of eligibility and kind of have that done and then move to the next question. So it's really just a process thought.
Yeah, I don't think that the next issue necessarily needs to be addressed before dealing with the eligibility aspect under 6213. So if that seems, discreet enough and the group would like to focus on this first, I think that would be appropriate.
Unless anyone disagrees, I think that's a good idea. Why don't we go ahead?
So I'll make a motion to approve the recommendations regarding eligibility.
I can bring up the proposed rule.
Great.
Just that
That'd be great, Erica.
everybody's kind of on the same page with that. So, hopefully everybody can see that. So this was the same rule that was brought to the committee last year, but the track changes that you see in red are recent updates. And so I thought maybe making sure everybody kind of understands what's encompassed in this proposal.
So it really, what you need is a motion to approve the proposed state bar rule, right?
Yes, so this would be, would then be brought to the commission for review and discussion as well. So yes.
Okay.
Correct.
To recommend approval then, I suppose, of this proposed rule, which I will do. I'll amend my own motion since it wasn't seconded. You need a second.
Yeah.
Hold on.
Okay, so Catherine makes a motion, Louise seconds.
I'll do roll call vote then.
Okay.
Alsaroff,
Yes.
Whitemaster,
Yes.
Blakemore,
Yes.
Connolly, Friedman, Corey, are you there? Still there? Okay. Oh, her voice. Okay, I see you. Okay. Meeker,
Yes.
motion passes.
Okay. Do we need to vote on the other piece of it, which was?
Yeah, so the other piece would be whether the group wants a proposal related to codifying the office approach regarding the pro bono aspect. Basically codifying the office practice that the higher income threshold would only apply to those organizations receiving a pro bono allocation. So if the group feels that it's sufficiently clear and no action is necessary, that's fine. Otherwise, staff and the working group can work to establish some language for review and consideration.
Just for clarification, I'm not sure what you're asking. If we have an unwritten policy, are we trying to codify stuff? And so we have an actual rule. And given that, do we need to have staff propose some specific language, or I'm not clear exactly where you think we should go.
Yeah, essentially whether there should be a state bar rule clarifying the part of the statute that says, you know, with respect to organizations with projects that provide services of attorneys in private practice, that section should be clarified to only apply to organizations that also qualify for the pro bono allocation under the funding, rather than any organization that has, say, like a one project under its full suite of services that provides pro bono services.
So the vote, if there's a motion and a second, would be for staff and the working group to go back and come up with that language, correct?
Yes.
Okay. Thanks for clarifying.
Do we have a motion for that? I suppose I'll make the motion. To go ahead. I can see Corey speaking. I'm not sure if she's seconding or not. Yes, okay, so we have a second from Corey.
Okay, I'll do roll
Why don't
call.
we take a roll call vote?
Al-Saraf,
Yes.
Whitemaster,
Yes.
Blakemore,
Yes.
Connolly, Friedman. Okay, I see you, Corey. Meeker,
Yes.
motion passes.
Okay.
So now we can move on to so the other main issue identified with regarding indigency was how to demonstrate indigency in the impact litigation and advocacy work reports that are submitted yearly. Again, it's for organizations to show that their work on, at least in the case of QLSPs, that their work on behalf of a group or class of persons is qualifying when they're not serving individual clients. And the reporting requirements are different between QLSPs and support centers. And so this discussion is mostly focused on, or actually is exclusively focused on QLSPs and their reporting requirements. Support centers will be addressed under a different topic. So when QLSPs file their ILAW reports, some of the factors that they need to report on related to this ILAW work is the forum, you know, whether the plaintiff is indigent, the definition of the class if it's an impact litigation case, the description of the group of individuals who would benefit from the work being performed, whether majority of those who would benefit are indigent, the relation of the issues raised in the matter to the legal needs of indigent persons, and whether indigent persons are disproportionately affected by the legal issues raised. So these are sort of the different factors that organizations need to report out on when they submit these annual reports. This is the actual language for guideline 2.3.4, which relates to ILAW. for QLSPs. And, you know, we just emphasize the portion of the guideline that says you have to quantify the percentage of clients who are indigent, or the percentage of persons who would benefit from the services who are indigent persons. And it's this part of the guideline that we've received the most feedback from the legal aid community about, that quantifying this percentage, quantifying a percentage that would benefit is either just not possible, or that organizations have had to go to great lengths and expense in order to demonstrate the benefit, when they feel that there are other sort of more practical ways in order to demonstrate that without having to jump through those hoops. And, you know, as noted in the memorandum on the staff side as well, this is also administratively a very large task every year, because organizations need to report out on their top litigation cases, 10 litigation cases and 15 advocacy activities. And so if an organization has done that or more, you know, we could be reviewing over 800 individual activities across all staff members. And so it is pretty resource intensive on both sides. Some of the working group's considerations in terms of addressing the concerns related to ILAW. One was to set a minimum threshold, you know, that would trigger the requirement to report. So if an organization really doesn't engage in much of this work, that they may be exempted from needing to report it out if it's not really impacting or a main feature of their services. One example was, you know, if 10% of legal services or 100 hours cumulatively or less are devoted to these activities, that they wouldn't have to report. This is actually something that's in our guidelines, but it's not currently enforced. The feedback that we got from the legal aid community related to that was to use, you know, the greater amount. So whether it's 10% or more, excuse me, yeah, the greater number of 100 hours or 10% rather than the lower number of those two. So the only potential issue with that approach is that, you know, 10% of legal services for a large organization could actually be a significant amount of funding. And given that this would figure into the organization's application on a yearly basis in terms of determining their qualified expenditures, both for purposes of being eligible to receive funding, as well as how much funding they would receive in the coming year in terms of their grant allocation. That was sort of the main concern with choosing sort of the greater rather than the lesser of these numbers. However, you know, we had circulated this and received some feedback, I think, from both LAC and one of our grantees, public advocates, on this point previously about how it may still be onerous for some organizations. And so this was the working group's initial recommendation in terms of having a minimum threshold, but that can be open for discussion. And then the other main consideration was to establish acceptable means for demonstrating the benefit to indigent persons without needing to actually come up with a specific quantifiable number. And so, or not needing to produce that independently. So some of the suggestions were to allow the use of internal data if independent data is unavailable to show that nexus between the needs of indigent persons and the legal issue. Some suggestions were, you know, the case summary report that the organization submits every year to the State Bar anyway, regarding major issues that they addressed in the previous year, what sort of services they provided and what was in most demand. Another consideration was demonstrating disproportionate impact to indigent persons generally, just based on the nature of the activity and based on the anticipated outcomes if the litigation or the advocacy activity is successful, which has sort of been employed informally, I would say, in the past couple of years when organizations aren't able to provide a specific percentage A number of those reports has come to the attention of the Eligibility and Budget Review Committee, and some consideration has been given to the organization's explanation of the reason why they undertook this activity, as well as what they expect to achieve, and are able to provide more detail as to sort of what generated the activity in terms of the work that they've performed with individuals or what they're seeing more broadly in the community as a need. And so after looking at that more closely, sometimes the committee has accepted that type of explanation as well. And so this would just be making that an official basis potentially for organizations to justify their ILAW work. So those were presented as sort of an and/or option. So allow organizations to do either of these things, or to show one or the other if necessary. So this wasn't meant to be exhaustive necessarily. These were sort of the initial thoughts of ways to ease the burden with the reporting requirement, while also assuring the commission that, you know, work is being performed on behalf of indigent persons, and that it can be allowed to count in the organization's application.
Erica, we've got two comments, Judge Seligman and then Catherine.
Yeah, I guess a question and a comment. The first question is on the minimum threshold to report. If you don't, under that theory, you wouldn't have to say anything about the case, or you wouldn't have to provide quantification. What exactly is excluded?
The first one would be you wouldn't have to say anything, so you wouldn't need to fill out the report because it would be considered so minimal as to, you know, not impact the organization's work or qualified expenditures significantly enough.
And this would be, and this is taking into account all of the impact litigation of an organization, not each case.
Right, correct. And I should say that part of where that came from is that a lot of organizations, they don't necessarily come in over this amount. They're not necessarily devoting a ton of time to this. I think the median amount was a little over 100 hours for many of them. So yeah, so for organizations where this isn't major, it would allow them to forego this part of the reporting requirement.
Okay, well, I understand that, and I don't have any inherent problem with the concept of setting a threshold. I am concerned about your comment that 10%, whichever is greater, does make a huge opening for very large organizations who could do a huge amount of work. So putting that aside, I just want to make another observation about, you know, the criteria that is there and a certain lack of reality, let me put it that way, about impact litigation. To me, when you look at impact litigation, you're looking at what the bang for the buck is, unlike an individual case. So to give an example, I can devote 100 hours to an individual case and get a remedy. And if it's an indigent person, great, 100% goes to there. I can devote the same 100 hours to a class action case. And if it's a large enough class, even if only 10% of that class are indigent, you may be impacting way more people in that litigation than in an individual litigation. So the idea that a majority or a huge proportion of a class need to be indigent kind of fails to take into account what you're trying to accomplish and what impact might be out there. So a lot of this quantification, to me, is frankly beside the point. I think if you have a case that is likely to impact, and I would use the word any significant number of indigent people, and given the size of the class, significant might be 10%, depending on how many people are involved, given the amount of time and energy is put in there. It seems to me that would qualify. I recognize the burden of providing data, and I would say if you adopt this kind of flexible approach, that what people, in order to demonstrate significance, the parties should provide, if reasonably available, and that's language I want to suggest, data. And the data can be from any number of sources. It may also simply be inherent in the definition of the class going forward. So I would push back on rigid statistical requirements that require the majority or the massive number to be there. It's really a cost-benefit analysis. If class litigation is going to benefit any significant number of indigents, it is likely a worthy investment of time compared to individual litigation.
Erica, Catherine
Catherine?
and Brady also.
Yeah.
Sorry, if you could remind us, because I think there's a connection between this exercise and the primary purpose of the organization. Am I remembering that correctly? Like,
Yes, to the extent that, you know, if a particular activity is found not to be qualifying, the organization in their application needs to deduct it from their qualifying expenditures. And depending on how much time or how many funds were devoted to that activity, it could impact their primary purpose potentially if it, you know, drops their percentage too low. So the other thing I wanted to mention when we do review these reports, I would say in any given year, only a handful of activities out of the hundreds of activities that are reviewed are ever found to be non-qualifying. So I think that was sort of the other consideration. So it hypothetically could impact primary purpose, but I don't know. I personally don't know of any instance where that has actually been a live issue. I don't know if maybe that's happened in prior years, but.
Okay, and then I get the other question I was going to ask. So under the number 1, 10% of legal services or 100 hours. So that's the threshold of when you have to report, but then the reporting would remain the same, right? You wouldn't, let's say it's 25% of your legal services are impact litigation, which is far more than the 15 or the 10 things you're going to be reporting.
Mhm.
Is it still going to be the same number, or now you have to report everything that fell within that threshold?
It would be based on the same number. So they would report their top activities in terms of hours devoted to them. And then what we have is sort of a catch-all. You know, if you provided more than these top 10 or 15 activities, then you need to provide a summary of the other ones, but you don't have to go through the entire report, which is more extensive. And so if anything is in those summaries that, you know, gives us pause that we need to follow up with them, where it seems like it might not be qualifying, then it is brought to our attention, but we haven't required them to fill out the same activity report for every single one. It would remain the same in terms of the top activities.
I mean, so long ago, we were required, when I was a director, this before the report the top 10, to report every activity. So my organization submitted hundreds of very detailed things every year, which that's when it was really burdensome. And then at some point it changed to doing this top 15. I don't actually remember the summaries, but we might have. So it's fine. Then I'm fine with that. I think it's going to be more burdensome if we went back to a system where people had to report in detail everything that they did. And I also think that the flexibility allowed by the second part will be helpful. I mean, there's been circumstances where, you know, if you try and say that it's a school case and schools serve, urban school districts serve low-income kids, and you're measuring that by who's eligible for free lunch, the free lunch threshold actually didn't line up perfectly with 125%. And then you're trying to like explain that in some way. So I think allowing that flexibility will be great. So thank you.
Eric, I think Brady was next and then Jim after that.
Yeah, so I was just going to comment on Judge Seligman's comment, and I don't know if he was suggesting a change. In my one caution would be, you know, clearly, and as set forth in the memo, the statute wasn't written with this in mind. I think that as far as our review of impact litigation, it is pretty generous, especially with the, you know, allowing, you know, a demonstration of disproportionate impact, through qualitative means rather than, just numbers. But I don't think that we can say, oh, if you're doing this big litigation that helps everybody, and it happens to be that a significant number of those are indigent, I don't think under the statute as currently written we can do that. I think we do need to, because it does ultimately need to be consistent with them having a primary purpose of serving the indigent. We don't allow huge organizations that serve lots and lots of people and end up serving a significant number of indigent people, but it's 30% of their clientele. We don't let them qualify. So, unless the statute's changed to have some different test for this kind of work, we do have to have some way of evaluating these that is consistent with the primary purpose language. I think that what we have does do that in a relatively flexible manner. Correct me if I'm wrong. We're not nixing much litigation, are we?
Yeah, can I just respond to that? We, like Erica's saying, we review not hundreds, pretty much thousands of these, and only a handful get elevated now to the committee to review. And of that subset, like Erica is saying, only between, I don't know, a handful of that. I mean, it's a sliver, maybe 2 or 3 or 4 a year that actually get disqualified. So we're talking about a really, really low number now. I think when we rolled out this iLaw report about 4 years ago, we had to elevate a lot more because it was a learning process in terms of what the commission felt comfortable approving. And also, so I think through the last 4 years, programs have a sense of what you will approve, and they've taken on cases that are more clearly. We just don't elevate that many cases anymore. So it's a little bit of a theoretical issue, I think right now, but I think more clarity obviously is helpful for everyone.
I think Jim had a comment as well.
My comment or question is on number 1, where the legal aid feedback was to use a greater the number. Is that coming from the larger programs like public counsel, who, because of the size of their staff, they're almost always going to meet the 100 hours, but they may not meet the 10%? And if that's the case, would this substantially reduce the workload on the staff as far as the number of these cases you'd have to review, since the larger programs are going to be excluded because they're not going to reach the 10%, even though they reach the 100 hours requirement?
I'm not sure about sort of who was giving that feedback. Selena might remember better than I do, about the size of the organization. I think even smaller organizations sometimes could reach 100 hours. So I think it would be a benefit to all organizations in terms of reducing their need to report if we were to make it the greater number. But I also think, yes, perhaps if larger organizations, didn't exceed 10%, then that would significantly cut down on the number of activities. I think if we went with the original recommendation to use the lower of those 2 numbers, we'd still be getting a lot of reports, because the analysis of, I think the median number from 2019 was slightly over 100. I think it was 125 or 140, something around there. So if we're using the lower of the 2, then a number of organizations are still going to need to report if they'll exceed 100.
And the follow-up, it sounds like that 100 hours was based on data. That is, if you say the median number was 140, so there's 100 hours based on that. And 2, I mean, I would think, unless there's a really good justification for the 100 hours, it seems to me like the 10% is an easy argument to meet Brady's threshold of what primary is, and that if that's what the agencies out there would prefer, seems like that would be easier on the staff to follow the 10%, or definitely the greater the 2 numbers.
Yeah, I think I agree with that aspect of the primary purpose. When you're getting into a number where it may actually impact primary purpose, but I do think the other consideration of
allocations to these organizations. If it's a very large organization, 10% of their funding could be a lot of money. And so in comparison to other, organizations working in the same county, if they're hypothetically allowed to count services that maybe shouldn't be counted, meaning they're getting a greater allocation to the detriment of other organizations, I think that's really the main concern there. But again, I think this is a little bit of a hypothetical issue given that so rarely is an activity found to be non-qualifying. So the working group hadn't necessarily come up with a proposed rule with these considerations. These were the initial proposals, and if this is the direction that the Rules Committee wants to move in, a proposed rule can be developed, but we don't have a specific rule today. It was more to have discussion on these points, whether to set that minimum threshold and at what level, as well as whether other means of demonstrating the benefit to Indigent persons should be specified in a rule.
I mean, I guess in terms of next steps, I don't know that we need to vote on this necessarily, but I think it seems like it might be useful to have particular language that we can talk through and we can consider as from the working group and from staff.
Can I make a suggestion, Amin? Because I know that this topic was put on hold because of a statutory change to move things forward. So if the committee is amenable to kind of this in concept, then we can actually take a motion and vote on that, and then take it back to the working group. And Brady and Erica and I can work with the working group to come up with proposed language, and then we take it straight to the commission. I know we have a few items that we need to start moving along to take to the commission, because then we need to send it out for formal public comment just to not backlog it again. We have a pretty heavy work plan for next year. And so if we rolled it back to the committee, my concern is then it would take and we actually have to add another meeting, or it would slow down our work next year. And if people are comfortable in concept, then I think we can do some of that legwork behind the scenes before we get to the commission.
Okay, Catherine?
Just one question. I'm fine with that approach to one. I just want to make sure the concept that we would be voting on is the lesser of, not the greater of then, even though that was the feedback. I really maybe, or just summarize what the concept is so we all know what we're voting on when we vote.
Erica, could you summarize it again? But I believe it's what's on the screen here, and it is that lesser language.
Yeah, it just says the feedback was to use greater, so I didn't want to be confused about what we all believed was the concept.
So the recommendation was to use the lesser of 10% or 100 hours. We did, want to bring to the committee's attention that there was feedback to use the higher amount, would be the preference from the legal aid community. But, if the committee or most of the committee is in agreement to use the lesser, we would, that would be the recommendation to incorporate into the proposed rule.
Well, doesn't that eliminates the administrative advantage though, if we do that?
I don't know if it would eliminate it. I think it would be, it's hard to tell at this point. It would reduce the number of organizations that need to report. I don't know by what exact number. We would still be getting a good amount of reporting.
Well, but by using the lesser, if you have a large organization whether it's public council or CRLA, they may not make the 10%, but they'll always be over 100 hours. So they'll always have to report. So you still got to, and those organizations have lots of cases. So they're going to have massive reports. So I'm not sure if that's, I was getting the sense that most of us thought that actually whichever is greater made more sense.
So I just think that that's why I was asking the question about what did the reporting end up being? So having worked at a very large organization that did lots of it, the massive reporting is less massive if it remains the same, which is reporting on 10 cases and 15 advocacy activities, which is what currently happens. If it's more than that, then I agree with you. So I think a common understanding that this is the threshold, but the amount that you're reporting is not every single case that you have in significant litigation, because it's not just it's not really just class, it's sort of anything else that's significant. So to me, I can live with lesser if the amount of reporting remains the same as it is now by practice.
Yeah, it used to be that programs like Catherine's, and it wasn't actually across the board, would have to submit their entire litigation docket. And so it would be every single case. So then we moved with the development of the I-law to be more consistent across all programs. So it's now the 10 and 15. I can never remember, is it 10 impact or 15 advocacy activities, but it's 10 and 15. And then if they have more than that, then we have the catch-all that Erica was talking about, that they just generally describe to us what those other litigation activities are. So they don't have to fill out separate reports. It's still a lot to review, but it seems more manageable. And a lot of these cases, as you all know, is from year to year. And so they're recycling the same description for us. So I think the first 2 years that we rolled out, it was a lot of work. But I think now that it's in the system and they can recycle the same, it's not as bad.
Okay, so should we go ahead and solicit a motion on this? I guess we would be voting on whether to send this back to the working group and staff to come up with language that would then be proposed to the commission directly.
Mm-hmm. Based on the recommendations on the screen here.
Correct.
It would be nice to actually see some data, like an organization or two, how it actually would impact them differently if you use the greater or the lesser.
I mean, the other option, if people don't feel comfortable, is that we could do a little bit more work between now and the next rules committee meeting. And I can't remember if we already posted that agenda, and try to tuck in an agenda item to, if say you want to think about it more, or us try to have some language in the next week. It would be a little bit tight for us, but I'm not sure, because I don't know if you're hesitating or you're thinking about it.
Yeah, I mean, I think for the next meeting, if it sounds like the committee wants to move in a direction of creating a rule, we can come up with language that then you can react to or respond to, make specific edits, and would give more time, to look into the actual impact, as Jim suggested. So if there's time to do that for November, I think that would work.
Yeah. So we do have time to amend the agenda for November 5th. If you want us to bring it back
okay,
with more information or language.
I think that's the sense that I'm getting as well. But yeah, Selena, did you want to?
Yes, sorry about that. I think that what would also be helpful is to figure out, if you're able to, with the data, to understand that the number of I-law reports you might get, especially as we have new IELTS funded programs. If you had 800 the year before and we keep the kind of current status quo, does that mean we'll have 850 and then 900 as we add more and more IELTS funded programs. And I just want to acknowledge that I know how much staff time is spent reviewing them, and you elevate so few that there is a little bit of like, what is the benefit to the community for all of your staff time to be invested in this? And if you're catching a lot that actually does impact an organization's QEs, then it is important because it does impact the size of the grant. But if you're catching very few, and even those that you elevate don't typically get overturned, I think that there's just like an efficiency argument here, especially just acknowledging all of the grants that you administer and the additional staffing time needed for all of the new grants and HP3 and HP2. And I just wanted to note that that's a lot of staff time. And if there is an efficiency argument that actually helps the community, I would definitely be in support of decreasing the number of ILR reports that staff need to read.
Yeah, we can get those numbers together. I think that actually would be really helpful.
I think that makes sense. And then I think, in terms of the quality of the discussion and feedback, it may be useful for it to come back to us before it goes up to the commission.
Sure. Okay.
At least the sort of in-depth nature of the discussion.
Yeah, we can do that, and then perhaps even if we can get it together, if some draft language might help you. Okay.
Yeah. Thank you. Do we need to vote on that?
No, we don't need
just
to vote on that.
Okay.
So Erica, I think is that the end of. So I think that's all our business items today then.
Okay. All right. Thank you, Erica. Thank you, everyone. I wanted to before we break, I wanted to bring up two things. One, to say, in light of Dwan's email yesterday about the recent legislation, to say thank you to everybody. Congratulations to everybody on the pieces that the Rules Committee were instrumental on in terms of SB 211 and SB 498. I think, and staff, it's been incredible getting those changes through and having these in-depth discussions. And I know we were on a tight time frame for some of it, which was, but there are now more tangible pieces to the work that we're doing on the Rules Committee. So thank you to everybody for your work on that. And I think this is going to be an exciting next year. I think there's some big topics coming up. Dwan and I have had some discussions about the work plan, and I think we're going to adjust things around to accomplish, to move forward and with what we want to accomplish without creating too much burden on everyone. And also we're looking at, to the extent that some of the kind of structural changes in SB 211, to the extent that those might have an impact on our work or how we are doing our work, we're also looking at that. So I think more to come in terms of our work, but thank you to everybody.
Can I just ask one quick question for the change in the commission, in the statutory changes about the commission? Which bill number was that in? Just so we could all look at it.
The 211 is the commission, expanding the commission's authority, but 211 also has the changes for expungement, which we always get confused because it seems like it would make more sense in 498 with the income threshold, but yeah.
But you just put it where you can put it, so.
Yeah.
I agree I agree. People did an amazing amount of work, and I particularly appreciate the support of the staff that spent a lot of time both before, particularly on expungement, and after getting it through. So it's a great change.
And we appreciate all of your help.
Anytime.
Yeah, thank you.
Okay. I think that covers everything that we wanted to accomplish today. So thank you, everyone. Have a great rest of the week, and we'll see you next time.
Great. Thank you, everyone.
Bye.